It does provide a very convenient argument for Mr. Edwards to hide behind an NDA so that this court would not be able to calculate guideline support based on the severance that he's receiving from that separation.
You also own a motorcycle, don't you?
I do.
Is an interstate case appearing for, let's see, respondent father is Mr. Edwards, and he is present with his counsel, Maratha. Now, Ms. Howard is the out-of-state litigant, and she is participating in this proceeding from her location. AAG Tatum appearing for the Attorney General's office. Okay, now, Ms. Howard, I do have from your state the general testimony that would have been prepared and sent to the Texas Child Support Agency. Are you going to be providing testimony in this matter?
Not that I know of, Your Honor.
So you'll be just observing and at this time, that way I just need to make sure. Okay. So Mr. Tatum or Mr. Maratha, will you be calling Ms. Howard as a witness other than what she has already provided in the general testimony?
No, Your Honor.
I will not be, Your Honor.
Thank you. All right, Mr. Edwards, please unmute your device and raise your right hand. Nothing but the truth, so help you God.
Yes.
Thank you, sir. And Mr. Edwards, I do see that you have, I think you have a hoodie on. Is that right?
Yes.
Your head covered. Is it for medical or religious purposes, sir?
No.
Okay, so I'll need for you to just remove that hoodie from your head. Thank you, sir. All right. Mr. Tatum, you may proceed.
Thank you, Your Honor. The matter before the court, as the court has noted, is brought by the Attorney General Child Support Office of Texas. Do ask the court to take judicial notice of the contents of the court's file, including the petitioner's testimony as provided by the initiating state in this case. This is a case that's filed under the Uniform Interstate Family Support Act, and we're ready to proceed. I'm anticipating, Judge, that we'll be heading towards some temporary orders here unless the court sees fit to do something else.
Okay. All right, take judicial notice of the contents of the court record.
This time, Your Honor, I will offer, the court may have noticed from its review of the court's file that there was an order for DNA testing at the request of Mr. Edwards and his attorney. We do have that report back. I've provided a copy of it to the court. I've shown it to Mr. Rueda and Mr. Edwards in a conference room, and bears exhibit label A, exhibit A, and I will offer the DNA test report into evidence at this time.
Objection.
Okay, exhibit, it's marked as states 1. So exhibit number 1 is admitted, showing that the probability of paternity exceeds 99.9%. And so Mr. Edwards is found to be the biological father of the child.
I'm sorry, Your Honor, my copy says exhibit A. And I thought that's what I sent to the court. Was exhibit A.
Okay, so the office does send exhibits ahead
Oh,
of
I see.
time.
Somebody sent an exhibit to you ahead of time.
I think so.
Shall I screen share just to make sure that it's the same thing?
I have it, exhibit A. Okay, so it's marked as exhibit A, so that's admitted.
All right. Thank you, Your Honor. Any order that may be handed down by the court today, I'll attach it as an exhibit to the order as well.
Thank you.
And incorporate it. So let me call Mr. Edwards then.
Right.
Mr. Edwards, will you open your microphone? And I am calling Mr. Edwards as an adverse witness.
Okay.
So, Mr. Edwards,
Judge, I'm confused. What do you mean adverse witness?
well, he's certainly not my witness. I'm calling to get his testimony.
Just as a witness.
Just as a witness. Okay, that's fine.
Thank you.
So, Mr. Edwards, first of all, how old are you, sir?
28.
Okay. And besides the child in this case, Isaiah Howard, Do you have any other minor biological children?
No, sir.
Very good. Mr. Edwards, are you currently employed?
No, sir.
Who was your last employer?
Apple.
And how long did you, that was the computer company?
Yes, sir.
All right. And how long did you work for Apple?
About 7 to 8 months.
Okay. And what was your pay rate at Apple?
At the time, it was 23 an hour.
Okay. Did you start at 23 an hour?
Yes, sir.
And you finished at 23 an hour?
Yes.
And were you getting a 40-hour work week?
Yes, sir.
And were you getting any overtime?
No.
When did you separate from Apple?
October 5th, 2023.
And did you quit?
No, I was terminated.
Were you terminated for cause?
Objection, Your Honor. The determination in this case is actually based on a non-disclosure between employer and employee and cannot be divulged either in open court or at any time.
Mr. Tatum?
Well, that's rather convenient.
And by the way, Judge, I made Mr. Tatum aware of that previously.
Say that again?
I made Mr. Tatum aware of that previously, that can't be mentioned based on a non-disclosure that was signed between the employer and the client. So I'm not really sure why that was asked.
Okay, so he's got a non-disclosure agreement, NDA with Apple.
That is my understanding, Your Honor, and that the parting of ways between my client and Apple were when they parted ways, he signed certain documents, including an NDA that was that the reason for the separation between employee and employer was not to be disclosed. And again, I mentioned that to Mr. Tatum to not have essentially not to have this conversation on open court.
Objection is sustained.
All right. So, Mr. Edwards, would you say that your separation from Apple was an agreement of the parties, employer, employee?
Yes.
Okay. Was there a payment, a separation as part of the separation agreement?
Objection, Your Honor. I'm going to object again. The terms of the separation between the employer and employer are all confidential, including any and all payment, reason why termination.
Not asking about reason for termination.
I
But the court, I
understand,
think,
but
is
any,
entitled to know if he received a separation of payment.
if I can finish my objection.
Go ahead, Mr. Rutha.
Any of the terms of the separation, whether financial or otherwise, or reason for termination, anything that's disclosed as to whether there was money paid out for any particular reason, all of that is confidential, and we're going down this rabbit hole that could violate this NDA, Your Honor. So I'm objecting to any questioning, any line of questioning that has to do with any packages or severance or reason for termination, anything that could be included in that NDA.
But Mr. Rutha, severance, I believe, is when calculating support, that is to be considered as income.
No, I understand that, Your Honor. Again, the reason why I'm objecting to this line of questioning is because in this particular situation, all of that, whether there was fault, the employer's fault, in the termination or accusations or anything that has to do with this employment, whether there is I can't get into it any further, Your Honor, but I believe that I don't want to subject my client to any kind of questionings regarding the termination that it can be contained in the NDA that could adversely affect him with a potential lawsuit. And those NDAs are very sensitive, Your Honor. Yeah.
Well, I'm not sure how to rule on that, since it seems that it does provide a very convenient argument for Mr. Edwards to hide behind an NDA so that this court would not be able to calculate guideline support based on the severance that he's receiving from that separation. Perhaps your client can testify as to what income he's receiving, which is as defined in the family code without disclosing the source.
I think that would be appropriate. I don't know if my client's currently receiving any money. I mean, the termination or the separating of ways was only 6 weeks ago. So it's if I would not object if the state were to question my client regarding if he's receiving any current income at this time.
So my question though is whether or not he received a lump sum as a part of a severance package. I'm not asking about what the agreement is or who was accusing who of what, who did or did not do anything wrong. Only asking about dollars and cents, Your Honor, and I think the court's entitled to know that, even if it was a lump sum severance.
And I think the issue for in this particular case is it may violate the NDA, which I haven't seen it, but there may be a violation of the NDA if Mr. Edwards discloses the source. I think he can answer a question generally if he's receiving any income. Okay. So Mr. Edwards, what income are you currently receiving? The amount.
I am currently not receiving any income.
Okay. All right. Ms. Howard, are you still with us? I just see a ceiling. Okay. And I don't mind you participating in this hearing, but you need to continue having your image, okay, on the screen so everyone can see you. If you wish to not participate, that's fine. You may leave the hearing. Okay. Mr. Tatum,
So you say the separation date was October 5 of 2023. Is that correct, Mr. Edwards? I'm sorry,
Correct.
Mr. Rada, are you there?
I'm here. I'm having camera issues. I don't know why my camera just got turned off.
okay.
I'm trying to fix it.
All right. Thank you, sir.
Should we wait?
There he is. I think we can go forward. Mr. Edwards, I wasn't sure if you answered the question.
No, I hadn't finished asking a question. It's just,
Go
so
ahead.
you said your date of separation was October 5, 2023. Have you on or since of October 5, 2023 received any lump sum payment from any source?
No, sir.
Objection, Your Honor. We're asking asked and answered. I believe this was already ruled on by the court.
Yes, he did answer no income
No, I
received.
asked my specific question was if he received any kind of lump sum from any source. A lump sum. And I
Again, Your Honor,
believe you did.
that is trying to circumvent the sustained objection as to whether or not that lump sum could be interpreted as a severance package, Judge. Again, I believe my client testified that he's not currently receiving any income at this time.
Objection sustained.
Thank you, Your Honor. Where did you work before you worked for Apple?
I worked for Accenture
And how many years did you work for Accenture?
3.5 years.
And did you move from Accenture directly to Apple?
Yes.
Were you doing the same kind of work for Accenture that you were doing for Apple?
It was similar.
Can you describe for the judge what kind of work you were doing in general without revealing any trade secrets or violating any non-disclosure agreements?
I was part of a team that helped identify compromised accounts.
Okay. Did you have some training for that?
Yes.
Was the training provided by the employers or was it some vocational training that you took yourself?
It was
Or both?
provided by the employer.
Did you finish public school, sir?
Yes.
Okay. Did you take any kind of vocational training or college?
No, sir.
So what qualified you to do those jobs when you first hired on with Accenture?
Uh, I'm not sure, sir.
Did you have some prior experience?
Yes.
So who did you work for before Accenture?
I had experience working in the tech industry through sales and customer support for other tech companies.
I ask you which companies you were working for before Accenture.
Before Accenture, I worked for a company called Everrise, where our client was Indeed. And prior to that, I worked for a network solutions company known as Juniper.
Okay. Indeed would be the employment agent or I'm sorry, Judge. I thought I had my phone on silent. That takes care of that. How far did you go through public education? Did you graduate high school?
Yes, sir.
Have you taken any kind of vocational training
No,
since high school? Since high school?
no, I have not.
Have you taken any kind of college courses?
No,
You know,
sir.
I think we've asked and answered that already.
Overruled.
So going back to your years with Accenture, you worked for Accenture for the entire year of 2021. Is that correct?
Yes.
And would you agree with me that for the calendar year 2021, you earned a little over $47,800 working for Accenture?
I would agree.
Okay. And for the calendar year of 2022, working at Accenture, would you agree that you earned a little over $52,000, almost $53,000 for the year 2022? Would you agree with that?
No, sir.
Okay. What would you recall earning in 2022?
I'd say it was closer to about 45,000.
Okay. And then for the calendar year 2023, you worked for both Accenture and for Apple. Is that correct?
Correct.
Would you agree that for the first 9 months of 2023, working for both Accenture and Apple, that you earned a little over $40,000?
I can't say. There was a
Were you making about the same kind of money for Apple that you were making for Accenture?
yes, sir.
So since October 5 of 2023, can you describe for the judge what efforts you have made to find new employment?
I am currently in the process of updating my CV or resume to start to apply for new jobs.
It's been almost 2 months since you separated from Apple, correct?
So to say yes.
Okay. And how many employers have you applied to since October 5?
A few.
Okay. Are you using the Texas Workforce Commission and their resources to help you find employment?
At the moment, no.
All right. Are you using an employment website?
Like a recruiter,
Well, like Indeed, for instance.
to a limited extent, yeah.
So you're living in Austin right now, is that correct?
Yes.
And you're living in an apartment?
Yes.
Do you share that apartment with anyone?
No, sir.
What's your rent?
Currently my rent is $1,400 a month.
Are you current on your rent?
Yeah.
Okay. Do you have a car?
Yes.
Do you have a car payment?
Yes.
What kind of car do you have?
A Toyota Corolla.
What year model?
It's a 2018 Corolla hatch.
Is that paid for, or are you making payments on that?
I am making payments on that.
What's your car payment monthly?
About $360 a month.
At your apartment, do you have to pay for utilities, or is that included in your rent?
Yes, I pay for utilities.
Okay. What would you estimate your utilities are costing you monthly?
Let's say maybe two to $300 a month.
Do you have insurance on your Toyota Corolla?
Yes.
What's your insurance running you?
That runs about, I'm not sure. My parents pay for my insurance on my vehicle.
Do you reimburse your parents?
At the time, no, I don't have a job.
When you have a job, do you reimburse your parents?
As of right now, no.
Okay. What else do your parents pay for?
A lot.
Cell phone?
Yeah.
Groceries?
Here and there.
Internet?
No, I have my own Spectrum.
Okay. What's your monthly charge on that?
That is about $75 a month.
Does that include cable for your TV?
Yeah, it's included in the like apartments package.
Nice. Do you have any streaming subscription services?
Typical like Netflix, Hulu, and stuff like that.
Who pays for those?
Myself.
What would you guess you pay total for all of your streaming subscriptions monthly?
Maybe about $30 a month on entertainment.
Are you doing any work on the side?
Currently, no.
Have you been in the past or since your separation?
Here and there, I've been looking for some side work here and there.
You also own a motorcycle, don't you?
I do.
What year model is the motorcycle?
It's a 2017 Kawasaki Vulcan.
Is it paid for?
I'm making payments on it currently,
What's your monthly payment on your motorcycle?
about $200 a month.
Okay. And your parents are paying for your motorcycle insurance also?
No, that would be me.
Okay, what's your motorcycle insurance cost you?
Currently I'm paying quarterly in the amount of about $100-something, about $100 every few months.
About $33 a month average?
Yeah.
Are you current on all of these monthly obligations, sir?
No,
Which ones are you behind on?
I am currently behind on the motorcycle for one.
Okay. Are you current on all of your internet?
Yeah, I have my internet on auto pay, so that's current. I am behind on my credit card, and things like that.
You have a credit card.
Yes.
Okay. What's your current balance on there?
My current balance? I don't know. I'd have to check.
Did you say you're behind on that?
Yeah.
So you're current on your rent. Are you current on your car payment?
As of right now, yeah.
Are you current on your utilities?
As far as utilities and car, yes. The bike and the credit card, I am behind on.
Do you have any passive income, money that comes to you without you having to work for it? Like,
No.
for instance, an oil well
I wish, no.
would be nice, right? Are you currently receiving any benefits as a trustee or a beneficiary under a trust? I'm sorry.
No, sir.
Are you currently receiving any amortized payments for any purpose, such as disability or a lotto win or anything like that?
No.
Have you applied for unemployment benefits?
Not yet, sir.
Are you intending to?
Your Honor, again, I'm going to object this on a questioning because again, I don't know if applying for unemployment or not applying for unemployment. Again, not trying to be evasive, but don't know if that is mentioned in the NDA as far as whether there
Wasn't
could be
gonna-
a. Go
I
ahead.
wasn't gonna, if he was going to say no, I haven't applied for it. I wasn't going to ask him why. I'm just asking if he has or if he's intending to.
I'll
I'm not
withdraw my
sure
vote.
if I would qualify for it. I'm not sure.
All right.
I haven't looked into it yet.
All right. I'll pass the witness.
Mr. Maratha?
Thank you, Judge. Mr. Edwards, I'm going to ask you a few questions that you may have already answered. I'm going to try not to be too repetitive. There were some questions asked of you when you work for Accenture, but you don't work for Accenture anymore, do you?
No,
Okay, and you haven't in a while.
correct.
Also, you were asked that whether you work for Apple. You don't work for Apple anymore, do you?
Correct.
Okay, so right now you're currently completely unemployed. Is that correct?
Correct. Yes.
And you have been looking for a job, as you stated.
Yes.
Now, the work that you did at Apple or software, that's a pretty refined type of job description, isn't it?
I'd say
Section,
so.
I'm not sure what the question means by refined.
I mean, these jobs aren't like going to applying at a restaurant as a server. I mean, they're very specific type jobs, are they not? Based on your expertise in software.
Yes.
So there are more. You would say that it's more of a limited field than many other jobs working in
Objection. That's
software. Is that
leading.
correct?
That's leading. I don't mind some leading questions as a judge, but I think that one goes too far.
I did not understand your objection, Mr. Tatum.
Leading. Form of questions, leading.
Mr. Maratha, if I'm going to sustain the objection, it may be rephrased.
Sure. Based on your personal knowledge, are software jobs as readily available as most other jobs?
No.
Based on your understanding of this field, is it more difficult to get a job in the software industry for companies like Apple than most other jobs?
Certainly, yes.
Now, let's talk about all these bills that you have. When you bought your motorcycle, were you employed?
Yes, that's back when I worked for Accenture.
Okay. When you signed your apartment lease, were you employed?
Yes.
When you bought your vehicle, were you employed?
Yes.
When you signed for your apartment knowing you would have utilities, were you employed?
Yes.
So is it accurate to say that these bills that you've incurred that you currently have, you could afford when you were employed?
Yes.
Now, have you been receiving financial assistance from your parents?
Yes.
Can you tell us whether or not they give you any additional money besides paying your bills?
They help me out with like groceries and things like that. I had to get a new tire on my vehicle. And at the time I just couldn't really make that payment. So they helped me out to buy a tire for my car and things like that. They really helped me out a lot.
Okay. So your plan is it, do your parents help you with your rent, correct? They do help you with your rent, correct?
Yes.
They help you with your vehicle, correct?
Yes.
They help you with monthly expenses, correct?
Yes.
Okay. And they're under no obligation to help you besides the fact that you're their son.
Correct.
Like they're under no obligation to pay your child support. You understand?
Yes.
I apologize for the camera. Now, tell me a little bit more about your resume. You said you were you're updating your resume. I'm sure it's a little bit different than when I was younger and updating my resume. What does that entail, and how long does that usually take to be able to apply online for jobs?
So I'd assume it'd take uh maybe a couple weeks to get my resume in the way that I wanted to be able to apply for the jobs that are most relevant to my skills and experiences and things like that. Currently, when updating the resume, basically what I'm doing is trying to highlight my relevant skills in order to find another really good job like the one that I recently departed from. So yeah, I'm definitely trying to get my resume up to par.
Okay. So would it be fair to say that based on your testimony that you could have your resume ready to roll and depending on the jobs available, apply to as many jobs as possible, maybe even deviate from specifics of software and have job interviews by January, February of next year?
I think that's fair to say.
Now, if the court were to set your temporary order with the child support at minimum wage between, let's say, $265 a month, would you be able to pay that and stay current for the next 3 months?
Yes, I believe so.
Is this something you would have to ask your parents for additional assistance?
Hopefully I won't have to ask them for any additional assistance when it comes to this. But I do know that they would help me if I weren't able to pay it.
And are you asking the court to enter a temporary order here today at minimum wage since you're not employed or receiving any income at all, until for a reset for like 3 months to come back to see if you're gainfully employed, hopefully in your field?
Yes.
Okay. Now, if the court were to set your child support at $23 an hour, we ran through those calculations, it would be impossible for you to pay that child support. Is that correct?
Correct.
If the court were to do half as much at $11.50 an hour, that would be virtually impossible for you to pay at 20%. Is that correct?
Yes.
Okay. But you're pretty confident that you'll be able to make minimum wage payments between 250 and 265, somewhere around there, correct? I pass the witness, Joe.
Mr. Tatum?
Could I have a moment, Your Honor?
Yes, sir.
My computer's giving me attitude. So, Mr. Edwards, since you are presently unemployed, I'm assuming, and you can tell me if I'm making a bad assumption, I'm assuming that you do not have any health insurance available to meet the medical and dental needs of the child that's the subject of this suit. Is that correct?
Correct. At the moment, I don't have any insurance.
All right. I think that's enough, Your Honor. No further witnesses and the Attorney General will rest.
Mr. Ruther, did you have anything else, sir?
No, Your Honor.
So, Mr. Edwards, so that I'm clear on your testimony, you testified about certain expenses you have monthly, your apartment, your Toyota Corolla, your utilities, cell phone, groceries, internet, subscription services, motorcycle plus insurance, and then you have some credit cards. You were asked about what assistance you're receiving from your parents. You generally testified that your parents are helping you with your monthly expenses. So all these things I've just itemized that you testified about, are your parents helping you with all of these bills?
No, not all of the bills. Or not like they help me with like groceries and like rent, things like that. It's more of the main things.
All right, so your parents are paying $1,400 a month for your rent. They're paying your cell phone and your groceries. And everything else you're paying for?
I think there's a misunderstanding. No, they're not paying $1,400 a month for my rent. That is what my rent costs, and they help me with that cost, but they don't pay the full amount. It's more so like they would help me here and there. It's not like an allowance or anything. It's more so if I let my parents know that, hey, you know, I don't have any groceries in the house, they may help me by sending me some money to get groceries, or if I can't make the full amount of my rent, they'll help me in that aspect, things like that. Or if I'm late on a payment for my vehicle, they're just kind of helping me here and there. It's not like a specific thing that they like they're not paying the entire amount of rent. I still have to come out of pocket too, and they're just kind of helping me and supporting me where I fall short.
So since October, when you lost your job, which months did your parents help you with your bills?
Every month since then. I lost my job in October and I had to pay, they've helped me with my bills this month.
All right, so in October, your parents paid, because I'm a little confused. You're saying they don't pay the full amount. So in October, how much did they pay for rent?
They put $1,000 towards my rent.
And you covered the rest, the 400?
Yeah.
Okay. In October, for your car payment, $360, who paid that?
My mom.
Okay. Your utilities for October, who paid those utilities?
I paid my utilities.
Okay. And how much were your utilities for October? If you can.
I'd say between $200 and $300 for utilities alone.
Your cell phone and your groceries in October, who paid for that?
My parents.
Okay. Your internet, who paid the internet in October?
I did.
Your subscription services, who paid that?
I pay for those.
Who paid for your motorcycle in October?
I paid for that.
Okay. Plus the insurance?
Yes.
I have that correctly. it's like $588 in October. So you had some money then in your account to pay for your bills in October, that portion?
I did what I could, yeah.
Okay. Now we're in November. Okay, so we've got this month. Which of the bills did you pay for in November?
I paid for utilities. I'm sorry. I thought you just asked me this. Ain't that what we?
I'm asking you for October. I'm trying to figure out how you're able to afford a $1,400 apartment, all your bills. I'm not very clear if it's your parents paying for all of it or you're paying for some. And if you're paying for some, I need to know how you're making it.
I used to have a job. I was employed and I was able to afford these things when I was employed. When I signed a lease to move into this $1,400 a month apartment, I was employed.
Mr. Edwards, I'm talking about since your separation. Okay.
I know I'm
Mr. Edwards. I'm trying to determine whether there is some evidence to impute any sort of income. Okay. All right. And you're arguing that your support should be based on someone that is unemployed. But apparently there are some resources that you have available. If you're telling me you have no income, but somehow you're able to pay close to $600 a month, I'm trying to figure out how that is. And I know you were employed before October. I'm not talking about that. But you have had, according to your testimony, you have had no income for October. You've had no income in November.
correct.
So where did the money come from for you to pay $600 or nearly $600 a month?
So the money that I've spent since my separation with my previous employment, that money is money that I've had in my account.
Okay.
Since then, I have not received any income in any form. So now fast forward from October to the end of November, I'm struggling to make ends meet because that money that was in my account has ran out and I don't have any more coming in. So I had to lean on my parents for help getting by with things like groceries, a tire for my car, helping me with my rent, helping me pay my car payments, things like that. So as of right now, I don't have any income.
You have money in savings.
I had money in savings. I don't have anything right now.
Okay. Thank you. Any other follow-up questions from any of the lawyers?
From me, Your Honor.
No? Okay. All right, Mr. Tatum, I know that you've rested. Did you have a closing argument you'd like to make?
Well, I think the court can see the issues here, Judge, for the most part. Maybe just a couple of comments. As the court noted, it's very convenient for Mr. Edwards to hide behind a non-disclosure agreement that he cannot show to the court. Perhaps the court could ask Mr. Edwards to produce that in camera for the court's inspection only. I don't know. I'm a little frustrated that it seems to me like there had to have been some sort of severance package that, you know, as far as just the dollars and cents the court should be able to look at, but I guess that water's passed under the bridge. My concern here, Judge, is that this man has more than, you know, a minimum wage earner is an earner who has no skills, somebody who, you know, can either push a shovel or flip a burger. Mr. Edwards has more skills than that. He has more earning potential than that. And it concerns me that here we are almost 2 months after his separation and he doesn't seem to be concerned, or maybe that's not the word I want. It doesn't seem to be a high priority for him to find new employment. He's still updating his curriculum vitae or his resume. So I'm just hoping that the court will set a temporary order here that recognizes that Mr. Edwards does have some skill and perhaps give him some incentive to get on with the job finding. I think coming back in January, February, or maybe even March might be appropriate to see if he's found his new job. Let's reserve the retro issues for now. And I would appreciate the court to follow through as the family code requires to instruct Mr. Edwards to present to his attorney the documentation that the Attorney General has requested, bank accounts, tax returns, W-2s, and any other proof of income that he can provide without violating a non-disclosure agreement, so that we can have a little clearer picture of what he's earned in the past, because we do still have a retroactive issue to determine here, Judge. Also, if Mr. Edwards is claiming that he's made any payments, he needs to produce some documentation of that, provide that to his attorney for his attorney to provide to the court and to the Attorney General's office to address that issue in the future. Let's reserve court costs on this as well. And I'm just hoping that the court will set a temporary support on something more than minimum wage for a gentleman who's got some skills here.
Thank you. Mr. Maratha?
Yes, Your Honor. Just want to address a few points. I know the state's stated that it's very convenient to hide behind NDAs or whatever it is that they stated. Judge, it's never convenient to lose a job. It's never convenient to separate yourself from a company or part ways from a company where you're fully employed and have health benefits. It's never convenient to have to sign an NDA and to be unemployed. It's never convenient to ask your parents for money to be able to make ends meet. So I don't see that argument. As far as my client's skills and flipping burgers, and he can do much better, I agree. I think my client can get a job where it would be above minimum wage and hopefully equal to or even more than what he was making at his previous employment working in software and tech. The good news is that in Austin, we are very tech friendly, and there tends to be a little bit more jobs here than there are in other parts of the country. And that's why I'm asking the court to reset this with a temp order to give Mr. Edwards the opportunity to apply within his fields, not just as the state stated, flipping burgers. He does have a very unique skill set. And Judge, I can appreciate the state claiming that because of my client's intelligence or ability in the field in which he works, or whether or not the state believes that there was a severance package or wasn't a severance package, there has been zero evidence introduced in court today regarding my client's income, except for the testimony from my client stating that he has not received any income since the beginning of October and is currently not employed nor receiving income. Aside from that testimony, there has been no evidence to refute my client's testimony. So I am asking the court to find that at this time, my client is not working. He does not have a job, that he is actively looking for one in his field. But the court set it at minimum wage based on my client's testimony, based on the evidence provided here today, and based on the fact that he's been receiving assistance from his parents, so he's not homeless and he has groceries in his home yard. I also agree with the state. I do agree with the state that we do need to reserve the arrears are retroactive for final, and health insurance as well for final, Your Honor. I have nothing further.
Mr. Maratha, you had mentioned setting a case maybe, or setting this case in the new year in January, February. I know you have a busy schedule. Are certain dates that are available to you that I can
Your Honor, I guess that depends on the month. Whatever the court's available, I can let you know immediately if that day works for me.
I'm looking at, let me look at this office's schedule, for February. I know that their January started to fill up. I can tell you, I am ordering Mr. Edwards into the NCP Choices program. I want to give them an opportunity to work with him. So I'm going to look at some dates in February.
Okay.
So there's a February 4th, excuse me, February 6th on a Tuesday. And February 8th, the Thursday. I'm sorry, February 6th is a in-person docket. I will try to put this back on Zoom so if Ms. Howard wants to participate. So we have February 8th, February 15th.
Judge, I believe the 8th works for me. The 15th does not.
Okay. And Ms. Howard, I'm not sure what state you're in, but if we put this in the morning, is that going to be too early for you in terms of the time change?
No, ma'am.
Yeah, okay. All right. So we'll come back February the 8th, 2024, 8:30. All right.
Your Honor, may I address one issue here?
Yes, sir.
The court has taken judicial notice of the contents of the court's file, including the interstate petition that was filed along with the Attorney General's petition. And it does note that the child is currently being covered by a Medicaid provision in the initiating state. So we are asking the court, even in the temporary order, to order a government medical assistance program. And I think the initiating state would be happy to receive $25 a month on that.
It's reasonable.
So the only question is, what are we going to use for gross monthly resources or gross monthly earning capacity?
I did notice on the on these interstate support petitions, the only issues addressed in their petition are financial. So it's current support, retroactive support, medical support. So in establishing parentage, generally in in-state cases, the surname of the child is an issue, but it's not in these interstate matters. Okay. All right. I am rendering temporary orders. Let me just give just the general announcement I need to make. I'm the associate judge for the child support court. My decisions can be appealed. Any party in this matter may request a new hearing before a district court judge. The time frame to request that hearing is 3 working days after I sign orders. The Attorney General's office will prepare the order. It will be circulated for signatures, and then it'll come to me for my signature. You will know when it's signed. So if you decide to file an appeal, you'll have those dates. Okay. All right. Now, as to temporary orders, the parent-child relationship established between Mr. Edwards and the child, and that's based on the evidence admitted. As to medical support, Ms. Howard will continue with the government medical coverage, and Mr. Edwards is ordered to pay a cash medical support of $25 monthly, and it will begin on December 1st. As to current support, I've calculated support based on the minimum wage presumption, and so current support for one child, $25.
$225.
$225. Yes, and that will start December 1. Mr. Edwards is ordered into the NCP Choices Program. So Mr. Edwards, while we were in this hearing, there was a NCP Choices representative that was called to join the first Zoom ID. So after we get done with this hearing, you're ordered to go back to the first Zoom ID to get registered. They have a process, so you have to be interviewed by them so they can get started. The NCP Choices Program works specifically with child support cases through the Attorney General's office here in this county. You have a lot of skills. You have good background. I think you'll be a strong candidate for the program. It does require some effort on your part, like 30 hours, I believe, of job searching. You will have someone that will work closely with you so that you can get work as soon as possible. I think this program is a good program, and all right, Ms. Howard, I see that you're driving, so I'm going to remove you from this hearing since you're driving. Okay, the issues of retroactive support are reserved. The issues of court costs are also reserved. And Mr. Maratha, if you have not already done so, there are some responses to the production requests that I think you'll need to work on if the AG hasn't received that. Okay.
Yes,
ma'am. February 8th, 2024 at 8:30 in the morning. That's also by Zoom. Let me verify that. February 8th. Yes, it's a Zoom docket. Okay, so it's the same Zoom ID, doesn't change. So the first Zoom ID that you entered in will be the one that will be available in February. Okay. Is there anything else?
Does the court want to set a deadline for Mr. Edwards' compliance with the discovery requests?
Is he still within the 45 days?
Ooh,
Let's see.
that's an exciting question. Let's see. The petition was served.
Yeah. So I would say within the next 30 days, if you can get that taken care of, Mr. Raylan.
Sure.
And what about the non-disclosure agreement that we've had so much discussion about? Will the court order Mr. Edwards to produce that in camera for the court?
I'm going to object to that, Judge,
Right.
obviously.
Not at this time.
course.
I think that, and I'm familiar with them, and that it can, whatever benefits that Mr. Edwards may be entitled to receive. It's not unusual for those that are receiving some sort of severance through an employer to receive unemployment. I think there's certain, depending on how the NDA reads, there may be some conditions to allow a person to apply for unemployment benefits. That's something you're going to have to go through, talk to your attorney about, Mr. Edwards. But I certainly don't want to jeopardize anything you may receive from that severance if you're going to get one. Who knows? But both of these lawyers know any money received from the severance package is considered income. I mean, it's something to be considered in terms of economic for the resources and calculating support. Hopefully that will we can settle that before we come back.
All right,
And I'll
Mr.
definitely discuss that with my client, Your Honor. But
Yes.
again, he's already laid testimony today that he does not have any income or is receiving any current income. So I think that resolves that issue.
I hope so. Okay. I can see where the AG's concern is, and it is mine as well, that if there's any funds, I have to consider all of those funds in calculating support, not just income from an employer. If that's the circumstance for Mr. Edwards.
I understand. Your Honor. And if the state wants to send me a discovery request requesting that, I can list my objections on the discovery request.
Sure. Okay.
Well, Your Honor, the discovery requests are set out in the petition on page 2.
Not requesting an
Petition.
NDA though. So if you want to request specifically the NDA, you can request that.
No.
It doesn't specifically request any issue NDA.
I fought that fight and it's over.
Okay.
I mean, I know when to wave a white flag, counsel. I do.
Okay.
Been around
No
long enough.
worries.
Mr. Edwards, but with regard to the discovery issues remaining, Mr. Edwards was served on August 8th of 2023. So he's had more than 50 days.
I'm giving Mr. Rotha another 30.
Another 30 to, well, and that, in the interest of being fair, we are going into the holiday season here, Judge. So I was going to suggest January 15 as a deadline for producing.
Okay, that seems fair.
Appreciate that. That'll work. Thank you.
Comply by January 15.
Mhm.
All right. So maybe we can all have a relaxed Christmas and New Year's.
Thank you, Mr. Tatum. Appreciate that.
Certainly.
Thank you, sir.
All right.
All right, I'm going to
So
go ahead.
let's see.
Anything else before I conclude the hearing?
Let's see. Do you want Mr. Edwards' signature on the order, or will Mr. Rada's signature on his behalf be sufficient for the court as far as temporary orders go?
Mr. Rotha's signature would be sufficient.
Are you okay with that, Mr. Rada?
Yeah, that'd be fine.
All right. And then you're not requiring a signature from Miss Howard, are you, Judge?
No, sir.
All right.
I mean, you can certainly share a copy of the document, but I'm not requiring.
Of course. Of course. I'll do so. So these orders are rendered today.
Yes, sir.
And what's my deadline for getting the orders to the court?
I'll give you until Monday, the 5th. Is that December 5th? I believe.
Let's see, can I have a couple extra days, say the 8th?
Okay, 8th is fine.
Order entry by 12/8.
Yes, sir.
So if I've done my thing and I've gotten the orders to Mr. Rueda and he's not signed for whatever reason, I can submit them to the court without Mr. Rueda's signature, or?
Yes, sir.
All right. That answers all of my questions for the moment. Let's see, Mr. Edwards, I believe the judge has instructed you to return to the other Zoom meeting ID number.